to the internal affairs of a country that has not attacked any country, but it implements the ethnic cleansing. It is the first time that NATO is engaged in a conflict outside the political borders of its members. Notwithstanding the above, all the international provisions regarding the human rights aim to ensure that human beings live in freedom and with dignity. The essence of human security is the implementation of human rights. The collaboration and interaction between the international human rights organizations and political actors is indispensable for overcoming challenges and to ensure human security and implementation of human rights. Thank you very much.
Mr. Ossia, thank you very much for your presentation. I think that it's international protection of human rights. It's a very broad topic, and it's very difficult to be covered in 10 or less minutes. But I think that throughout your paper, you did a kind of effort to bring the main message that how the implementing or progressing in human rights is going to enforce even the international security, and trying to bring some example, legality versus morality in humanitarian intervention. I thank you for your presentation. Please, any comment or question? Any question, please? Before we start with the third, please.
Hi.
Hello. Yeah. I would like to know if you considered your approach was very historical, whereas I think personally that in the UN human rights have only taken an important position in the 90s, and I wondered if you'd looked at their mainstreaming of human rights to be included in the policies of each UN body.
Yes, the human rights are trying to be included in the policy, and the policy is trying to show the respect for human rights is the same everywhere. That was, for example, the intervention in the Kosovo, to make sure that human rights are samely respected in Balkans, in Europe, and one of the biggest challenges, I think, is the human rights in Africa or in other parts of the earth, because there are a lot of problems on those regions. We have a universal human rights declarations, and there are 3 systems, as I mentioned before, but the implementation is not the same. So that's why the different regions are trying to develop procedures, trying to develop institutions to ensure these human rights. This is a challenge for all of us, for all the humanity, let's say. Thank you.
Thank you. Any other question? Okay, thank you very much, Mr. Ossia. Now you will be hearing a presentation from Miss Ilma Bici. She's working as a lecturer at Badr University, Department of Law. Her presentation is going to deal with the juridical practice in the protection of human rights. Ms. Bici, the floor is yours.
Thank you.
Hello, dear panel members, dear colleagues, and all the participants of this important conference. I'm here today to present you my work, my paper, that concerns with the juridical practice in the protection of human rights. Everybody knows that when we talk about human rights, we are really talking for a very important issue. Albania, in our country, belongs to the civil law or the Romanic German family, and furthermore, the importance of European Convention of Human Rights is in the highest level. According to the article number 122 of our Constitution, we will see that the position of European Convention of Human Rights is in the same place as our Constitution. It means that in one moment, if we oppose anything on each article of the European Convention of Human Rights, is the same thing as we are doing something against to even our Constitution. To understand more clearly the respect and the protection of human rights, I'd like to present in the same time the main principles of the rule of law. The first is the open door judgment. The open door trial or judgment, according to the article number 6 of the European Convention of Human Rights, everyone has his right to be heard in the process before he gets or not his punishment. The participation of public and media is very important in a process in a court for two reasons. The first, because their presence there means that it won't take any action that we will have any discrimination in that process. And the second, because it's like a test to have a honest process until a final decision. The second is independent court. To have an independent court means to have these four factors. The first factor is the way of selecting the members of the court. The second is the duration of the duty. The third is the fact to don't have that anyone from the members of the court might have any pressures or indications from outside. And the last, to have an objective independence, means that how they feel to be independent in a process in the court. Access to court means that how open is the European Court of Human Rights to wait or to accept any claim that might have anyone in the respect of his rights. And the last but not the least is the presumption of innocence. The accused will enjoy all the same rights as any other person of society. Everyone must be respected by the prosecutor and by all the members in the court. So I think that the mechanism all the international mechanism have one only mission, and this mission is to protect the human rights. And the best way to do this is protecting, defending, and respecting these human rights. So I think that nowadays we can talk for a progressive nature of jurisprudence in the area. Ladies and gentlemen, thank you very much for listening.